Okay. Good morning. My name is Felicia Orth. I'm a hearing officer appointed by the Environmental Improvement Board to conduct a hearing in this matter. It's a petition for rulemaking docketed by the board administrator as EIB 21-27 related to air pollutants, which are ozone precursors. The hearing will be conducted in accordance with the board's rulemaking procedures, which you can find in section 20.1.1 of the New Mexico Administrative Code. We have board members present, so let me introduce them before I go any further. Member Sweeney is there. Good morning, Madam Chair.
Good morning.
We have Vice Chair Davis. See on the screen. We have, do we have Member Cates?
Yeah, here, yes.
Yes. Good morning, Member Cates. Member Bitzer, I think, was just speaking with us. There's Member Bitzer waving. Member Duvall, I know, was with us. Member Duvall. Member Garcia, there you are. Good morning. And Member Hunker, I know you're on.
Good morning.
Good morning. We also have the board administrator, whom you will hear me referring to quite a bit. There she's waving. Her name is Pamela Jones, and she will be a primary contact for a lot of you in a couple different ways I'll mention shortly. And we have board counsel Carla Solaria.
Good morning.
Good morning. All right. We also have we have a number of parties in this matter, about a dozen, and many lawyers representing those parties. I'll ask for appearances in a little bit. I need to make some comments first about the case, the virtual platform we're on, and our process. So all documents in this case, including the rulemaking petition, entries of appearance, direct and rebuttal, testimony, exhibits, motions, public comment, received at least as of this morning. All of those documents can be found on the EIB webpage, and in particular on the page that is titled Docketed Matters. As additional pleadings are filed or comments submitted, that will also be posted. The board will be hearing a lot of evidence and argument on this petition, and no decision will be made anytime soon. We expect the evidentiary hearing to last 2 weeks, hoping to end on October 1st, and there will be a multi-week post-hearing process following the close of the record. If you are curious about where we are in the process and it's unclear from the webpage, please reach out to the board's administrator, Pamela Jones, whose contact information is on the webpage. The hearing is structured to provide both for let's see, Member Cates, please mute yourself. The hearing is structured to provide for both technical testimony and non-technical public comment every day. There are currently 29 opportunities to offer public comment at 9 a.m. except today, 1 p.m. and 5 p.m. each day of the hearing. If you would like to identify a day and time during which I can call on you to offer public comment, please send an email to Pam Jones and let her know when you'd like to speak. Public comment can only be offered once, so please collect your thoughts before you begin, and is limited to 5 minutes. In the event the statements you would like to share with the board would exceed 5 minutes, please put those statements in writing. There are no page limits on written public comment, and the board will consider all of it in its deliberations. Written public comment must be received before we adjourn the hearing, again, likely on October 1st. So please get your written public comment in before then. In addition to non-technical public comment, we have, I believe it's 59 technical witnesses being presented by the parties, and the parties' representatives have generally agreed that the board would find it most helpful to hear as much as practicable that testimony by topic. Now, that won't be possible completely, that is to say, based on witness availability, for example, and other factors, but a lot of the testimony in this matter will come in by topic, meaning we won't hear from each party all at once in order. It remains one transcript. That entire transcript will be considered, and obviously in the post-hearing process, the parties will be able to make their arguments and lay out their evidence anywhere from that transcript. Speaking of the transcript, our court reporter today is Teresa Dubois. Because the transcript is the official record of this proceeding, it is important that she be able to hear everyone, and she has been invited to speak up at any time in the event she is struggling to hear someone, and we may have to ask you to repeat something if she didn't hear it the first time. I have hit the record button, and eventually the recording may be available, for example, on the board's webpage or another channel. But again, it's not the official record, the transcript is. So, although we have a lot of folks to hear from every day, we will generally take one morning break of about 15 minutes, one lunch break, which may or may not be an hour, and one afternoon break. The end of the day is a little more fluid. It depends in part on how much public comment is offered in the 5 o'clock session. It depends also on whether it's possible to wrap up a particular technical witness before we break for the day. So that's a little fluid. Let me say a few words about the platform. It is true, a couple weeks ago, the board administrator did put on the EIB calendar a link to the hearing in this matter, and that link, was replaced with a different link for each day of the hearing on the calendar, and was certainly there this morning when everyone wanted to check in. It was driven by the fact that the change in the link prior to this morning was driven by the fact that it was important to set this event up as a Cisco WebEx event rather than a Cisco WebEx meeting. And having said that, I tried to remove any requirement for registration, for passwords. Ideally, you can just click on the link for that day's hearing and get to us directly. I had some folks try it this morning and it worked for them. Having said that, we didn't want the original link to lead merely to an error message. So there is actually the department's CIO is sitting in the meeting that the original link would take you to with the information to join us here on this link. And if someone actually calendared the original link, it will be very easy for them to see the information that would allow them to join us here. So the board members and party representatives have joined as panelists and can control their own sound and video. Witnesses will become panelists when they are called upon to testify. No one will be made a presenter, meaning you can share your screen, until it is necessary to assign that role, and just know that I can only assign the presenter role to one person at a time. See, I'm making Mr. Bach a panelist. And lawyers and party representatives, if you would please do what a few of you have done this morning. In the event you have any trouble with the panelist link or panelist invitation, join as an attendee. Let me know somehow that you've joined as an attendee, and I will redesignate you. The remaining folks on the platform are attendees and will be unmuted as necessary in order to make public comment at the appropriate time. You will see that the chat function, which is in your lower right-hand corner, has been configured to allow only chat with the host. Pam Jones and I will be trading off on the host duties throughout this hearing. That is the only place your chat will go. Please do not put anything in that chat that is not about, for example, platform technology. The chat will not be saved or recorded, certainly not meant for any kind of public comment, which must come in either orally or in writing to the administrator. Board members and party representatives have been given a number to text in the event of serious technical difficulties. Attendees may communicate with a text to Pam Jones. Let me give you that number, 505-660-4305. With so many people on the platform, I will encourage those folks other than the court reporter and the board members to turn on their video only when they are speaking. And if you can, please avoid the virtual backgrounds, which, as the court reporter has noted, can interfere with the audio. Today, besides public comment sessions at 1 and 5 p.m., we expect to hear opening statements and some testimony, particularly from the Environment Department in support of their petition. We are working from a spreadsheet in which the parties have agreed to the general order of the topics here. That will definitely, could definitely change as we go on, again, based on witness availability. But we may well be hearing on ozone formation, ozone monitoring, stakeholder outreach to begin with. So I'm going to ask for appearances, Council. Not every morning, but this morning. And on that note, there, again, lots of board members, lots of lawyers and other party representatives. Having called for your appearances at the beginning of this hearing, I am not going to ask you to announce when you are coming or going. I turned off attention tracking. Um, uh, as far as I'm concerned, if you're on the platform, you're on the platform. And if you're not on the platform, you're not on the platform. The drawback there, obviously, is that if I call on you for any questions to cross-examine a witness and you're not in attendance, that time will have passed. We won't be recalling witnesses. Um, and once again, if you are not on the platform and it is a serious technological emergency, please text me and we'll work through that. So, Ms. Katz, if you would, I'm going to call you roughly in the order, with one exception, roughly in the order in which we prepared the service list. Ms. Katz, please.
Thank you, Madam Hearing Officer. Good morning, Madam Chair, members of the board. Laura Katz on behalf of the New Mexico Environment Department. I have with me today my colleague, Andrew Knight, also with the department. Thank you.
Thank you very much. Ms. Fox?
Good morning, Madam Hearing Officer, Madam Chair, members of the board. My name is Tanis Fox with Western Environmental Law Center. I'm here today with my co-counsel, David Bach, and we represent 9 clients today throughout the hearing, who we are referring to by shorthand as Clean Air Advocates. Thank you.
Thank you. Ms. Paranos?
Good morning, Madam Hearing Officer, Madam Chair, members of the board. Elizabeth Pranos here this morning on behalf of the Environmental Defense Fund.
Thank you. Mr. James and the others on behalf of Center for Civic Policy and NAVA.
Good morning, Madam Hearing Officer. I'm Daniel James with the University of New Mexico on behalf of Center for Civic Policy and NAVA Education Project. And I have Gabe Pasiniak, Travis Shumanek, and Kiefer Johnson here with me today.
Thank you very much. National Park Service, is Ms. DeVore with us?
Hi, Lisa DeBoer with the National Park Service, and I'll turn off my virtual background in a few minutes. So, thank you.
All right, thank you. Wild Earth Guardians, do we have Mr. Timmons or Mr. Nykiel?
Yes, good morning, Madam Hearing Officer, Madam Chair, members of the board. My name is Matt Nykiel. I'm here with Daniel Timmons, who's my co-counsel on behalf of Wild Earth Guardians. Thank you.
Thank you very much. Mr. DeSalen.
Thank you. Good morning, Madam Hearing Officer, Madam Chair, members of the board. I'm Charles DeSalen, and I'm here on behalf of the New Mexico Environmental Law Center.
Good morning. New Mexico Oil and Gas Association, who you'll hear referred to as NMOGA throughout the hearing.
Good morning, Madam Hearing Officer, Madam Chair, board members. This is Eric Heiser representing the New Mexico Oil and Gas Association, or NMOGA. I'm here with Brandon Curtis, also of my office, and we have co-counsel as well, Dal Molenberg.
Thank you very much. Mr. Rose.
Yes, Madam Hearing Officer. This is Louis Rose on behalf of the Independent Petroleum Association of New Mexico, and I'm here all by myself.
All right. Mr. Jano.
Good morning, Madam Hearing Officer, Madam Chair, and members of the board. My name is Scott Janot. I'm here on behalf of Oxy USA, Inc.
Thank you. Mr. Homestead or Mr. Swift?
Good morning, Madam Hearing Officer. This is Stuart Bootsier of the Modrell Sperling Santa Fe office, representing GCA, also Gas Compressor Association is the formal name. Whit Swift, who you invited to speak, is one of our co-counsel with the national law firm of Bracewell LLP. And I'm also accompanied by my partner, Christina Sheehan, from the Albuquerque office of Modrell Sperling.
Good morning. Ms. Gutierrez?
Good morning, Madam Hearing Officer, Madam Chair, and the board members and other parties. My name is Ana Gutierrez with Hogan Lovells, and I'm representing Kinder Morgan in these hearings.
Thank you. The Commercial Disposal Group.
Good morning, Madam Chair. Madam Hearing Officer. This is Chris Newman with Greenberg Treurig. And with me are Casey Spall and Greg Tan of Greenberg Treurig, Matthias Sayer of NGL Energy Partners, and Chris Colclazier of Beatty and Wozniak, representing the Commercial Disposal Group.
Good morning. Let's see, do we have Ms. Witherspoon on?
Yes, good morning, Madam Hearing Officer, Madam Chair, and the board members. Leslie Witherspoon representing Solar Turbines.
Good morning. I believe those are all of the parties who entered appearances and or submitted a notice of intent to present technical testimony. Let me turn then to some motions. Let me ask if other than the motions and opening statements, any of the parties have another matter that we would need to address before we begin taking testimony. All right, I hear nothing. Let's see. While we have all of you, the department filed two motions, one to strike the National Park Service NOI or Notice of Intent, and another to strike the Solar Turbines NOI. I did get responses both from the National Park Service and from Solar Turbines. The National Park Service repackaged, as appeared to be the request from the department, repackaged their materials as part of a rebuttal NOI. Ms. Katz, I'm inclined to accept the rebuttal NOI and their planned testimony in that format. Would you have anything to add if that were my plan?
No, Madam Hearing Officer, we agree with that decision.
All right, thank you. Moving then to Solar Turbines. I understand that there wasn't perfect compliance with service, for example, although I will note there hasn't been perfect compliance with the service list on behalf of a couple of parties. And I'm inclined to provide Solar Turbines with an opportunity to give the comment that they want to give. Other than assuring that there aren't, if you will, surprises, that in fact the testimony will stick closely to what was submitted, I'm wondering if you had any other comment there.
Thank you, Madam Hearing Officer. The department doesn't object to Solar Turbines giving comment. I do believe, though, that the requirements for submitting technical expert testimony were not complied with, and that's my concern, is guarding that process. So if there's some way to have that presented in a different manner, that would be fine.
Okay. What I'd like to do is make sure that Ms. Witherspoon understands that she'll be invited to, provide her comment at the right time. And to the extent we need to draw out a little more on qualifications, for example, or you would have very specific objections about a particular statement and whether, for example, she was qualified to make it. I'd like to address that at the time she's giving her testimony.
That sounds good, Madam Hearing Officer. Thank you.
All right, thank you. Let's see. There was Clean Air Advocates' motion to strike the commentary in NMOGA's Exhibit B and Exhibit 47. And here, let me just offer, I think I'm looking, for example, right now at Exhibit 47. This is very close to something I would invite the parties to do at the end of the hearing. That is to say, in your sort of closing arguments or your post-hearing submittal, tell the board what change you would like to make in each section, and then identify the testimony or exhibits that supports each of those changes right below it. Those of you who've been through a triennial review hearing with me, and that's several of you, know that I think that's the way it is easiest for the board to follow every party's proposal. And I may or may not, at the end of this hearing, I may or may not be asked to compile that. For example, in a report, the board won't make that decision for a little bit. But I think at this moment, it's premature, and my recommendation would be that the board disregard for the moment these comments throughout Exhibit B and Exhibit 47 because they're not, if you will, cited to testimony or to exhibits just yet. That record will be made as we go along. I think this sort of thing will come in very handy after the end of the record, but not just yet. So I don't know who would be speaking on behalf of NMOGA, but I'm wondering if we can get Exhibit B and Exhibit 47 without the commentary for now, understanding that at the end of the hearing, this may be very useful.
Madam Hearing Officer, this is Eric Heiser on behalf of NMOGA. While I don't disagree to some extent with where you are recommending that we go, I don't believe that it would be appropriate to remove this exhibit. And the reason is that it's referred to certainly in the testimony of a number of the NMOGA witnesses, but also by a number of the other parties. And so it is a critical part of the administrative record because you cannot understand the testimony of the other parties. And so I think striking it is inappropriate. I do think that we could leave it in for the purposes of the red lines, and that we will then, at the end of this hearing, if you would be amenable to that, file an evidentiary version of it, which would cross-reference those pieces of it that have been properly shown to be evidentiary, as opposed to a statement of reasons for the change. And then that could become an evidentiary exhibit, which we would move at that point, if that would be acceptable to you and the other parties.
Okay, I see your hand, Ms. Fox, but I'm going to talk a little bit further with Mr. Heiser. So, Mr. Heiser, if I'm going, though, to recommend that the board disregard this commentary at this point, again, I would recommend that the board look at it after the hearing when you've got record citations to it. But if I'm going to recommend that they disregard this, and in my mind, there's a distinction between what has been filed in the administrative record, which I don't feel I have the authority, for example, to destroy, if you will, or simply remove. I mean, it was filed, it's there. Having said that, I'm wondering if it would be more helpful, again, knowing that it's there. It was filed on May 6th, 2021, to have a substitute B and a substitute 47 that could also be part of the record, so that the board didn't have to go through the mental exercise of reading past it all.
I mean, Madam Hearing Officer, obviously will do as you direct, but to the extent that witnesses refer to, the original document, that creates problems in the understanding of the expert testimony that has been presented in direct and rebuttal.
Do you have something to add here?
Thank you, Madam Hearing Officer. I was going to make the same suggestion that you just made, and that is that NMOGA file a substituted Appendix B and a substituted Exhibit 47 for exactly the reason you stated, and that is so that anybody looking at those exhibits doesn't have to make their way through the comments. I think the extent to which this is an issue for NMOGA, it's an issue that is brought on itself, and it had an opportunity to cure with its rebuttal testimony, because this objection, I did raise this objection during our pre-hearing conference. And so I think the fact that NMOGA's witnesses referred to Exhibit 7, and it's a prior Exhibit 7, it's going to be substituted, and a little bit of a glitch there for the witnesses. I think that again is sort of a problem they brought on, and I think the record is much cleaner if they file a substituted Appendix B and a substituted Exhibit 47, so it's clear from the record that the commentary in those exhibits is struck.
Okay, thank you for that. Mr. Heiser, if I really think it would serve the board to get your red line, your proposed red line, without the commentary that I have to ask them to disregard. And again, I think this will be terrific in about 2 months, but I think it's premature now.
So, Madam Hearing Officer, do you want us to file a revision of the two exhibits, or do you want us to file new exhibits? Because we need to preserve page numbers and other things like that. We simply can't move stuff because it will cause all the line numbers to shift.
I see. So if you remove the commentary but leave the line numbers, the line and page numbers alone, will that be easiest for us as we all sort of walk through it?
Yes, we can do that. So we'll file this as a revision 1 of each of those two exhibits, which will delete the commentary. Although my understanding is that you're leaving the original document in place in case somebody needed to refer to it to understand the experts.
Exactly. Yeah, I'm not removing the original document from the record proper based on my reading of the board's rulemaking procedures. Having been filed, it's part of the underlying record proper. I am asking you to submit the revised exhibit so that I don't have to continue to remind the board to disregard something that was filed maybe just a little too early.
Very well, Madam Hearing Officer.
Thank you very much. My understanding is there was one other motion. It was filed yesterday, and it was a motion to strike the testimony of Professor Villa. Because that motion was filed yesterday and UNM has not had, Center for Civic Policy and NAVA have not had an opportunity to respond to it. And I think it's going to be a while before we get to Professor Villa's testimony. In my mind, it is too early to address that motion this morning. Okay. Anything else from council? I'm just going to pause for a moment. Anything else from council?
Madam Hearing Officer,
Rose.
we had identified earlier in this proceeding, I guess last week is earlier, maybe it was this week. There were about exhibits and testimony that there was at least a question about admitting testimony and exhibits en masse without necessarily offering them individually. We identified a number of exhibits and the testimony related to them we objected to, and I don't know whether it's something you want to address now or after opening arguments or in the context of admissibility when those exhibits are being offered. It may be prudent because they all the objections relate to a single point, that maybe we address those after we get to opening arguments, but before testimony is offered. So I think that may be the most prudent way to do it, but just wanted to alert you that that's still pending as well.
Thank you very much for that reminder. I do have that in my short stack here, surrounded by boxes and a short stack of documents. I did note that a number of the parties had no objection to any of the exhibits, but that NMOGA and IPANM had objections to certain of the exhibits. So when we got, for example, to the department's presentation, I was going to invite Ms. Katz to offer the exhibits that could be admitted en masse, if you will, and then have a discussion about the exhibits that we need to have some, just need to make a record as to the objections and have some argument about it before a ruling. So thank you for that. Anything else? I'll pause for just a moment in the event Party Council would like to identify any other issues. No. Okay. So let's begin with opening statements. I'm going to invite each party has a choice to make an opening statement now or to make an opening statement at the beginning of their presentation. So the department, Ms. Katz, whenever you're ready, please make your opening statement. I will call on the rest of you in the order in which I invited your appearances. Ms. Katz, if you would.
Thank you, Madam Hearing Officer. The department is here before you today to propose new rules to regulate emissions of ozone precursor pollutants from the oil and gas sector in New Mexico. These proposed rules are in furtherance of this board's mandatory duty as provided in the New Mexico Air Quality Control Act to address rising ambient ozone concentrations across the state. Specifically, the board is required to adopt a plan, including regulations, to control emissions of ozone precursor pollutants from sources within the board's jurisdiction that cause or contribute to ozone levels exceeding 95% of the Federal National Ambient Air Quality Standards, or NAAQS. The stated purpose of the statute is to provide for attainment and maintenance of the federal standards. Put another way, the goal is to try to avoid a non-attainment designation by the U.S. Environmental Protection Agency under the Clean Air Act and the corresponding burdens on the department and industry that such a designation would entail. In essence, the legislature wanted any requirements imposed on New Mexico sources for the purpose of controlling ozone levels to be prescribed by this board, not the federal government. This rulemaking is the first time the department has taken steps to seriously regulate the oil and gas sector, and it is taking place in the context of a massive expansion of this industry in New Mexico over the last several years. New Mexico is now the second largest oil-producing state in the country. Corresponding with the drastic rise in production, the department's air quality monitors located in closest proximity to the state's two largest oil and gas producing basins have shown consistently rising ozone concentrations. And that is why we are all here today. Before I go further, I would like to introduce the department's witnesses who will be testifying before you over the next 2 weeks, though not all of them are here this morning. Most of you have met Elizabeth Bisbee-Keene, Chief of the department's Air Quality Bureau, in previous hearings. You've also met Michael Baca, Manager of the Bureau's Control Strategies Unit. Cindy Hollenberg is the Enforcement Manager of the Bureau's Compliance and Enforcement Section. Angela Rosso is an air dispersion modeler in the Bureau's Modeling Unit. Brent Ellington is the supervisor with the Bureau's Ambient Air Monitoring Section. Andrew R. is the Quality Assurance Manager of the Bureau's Operations Section. We also have Brandon Powell from our sister agency, the Energy, Minerals, and Natural Resources Department, where Mr. Powell is the Chief of the Oil Conservation Division's Engineering Bureau. We also have some witnesses from our contractors that worked on this rulemaking. Ralph Morris is the Managing Principal of Ramble Environmental Health Central West Business Unit. Mr. Morris has over 40 years of air quality consulting experience and is one of the original developers of many of the photochemical air quality models that are used to support regulatory decision-making in the United States and around the world, including the model that was used to evaluate the ozone impacts of Part 50. He is truly one of the top experts in his field. We also have 2 witnesses from Eastern Research Group, who NMED contracted to help develop the provisions of the rule and estimate the costs and emissions reductions from implementation. Brian Palmer is a senior environmental scientist with ERG, where he has worked for 25 years. He has 30 years of experience in the environmental consulting industry and has worked on numerous air quality regulatory efforts at the federal level. Susan Day is a senior economist at ERG with 34 years of experience conducting and managing economic, regulatory, and data analyses supporting federal environmental regulations. These witnesses are a stellar team that has worked incredibly hard to provide you with solid justification for adopting the department's proposals. The proposed rule before you is the result of over 2 years of outreach and engagement with stakeholders and communities across the state. This process began in 2019 with Governor Lujan Grisham's Executive Order 2019-3, directing NMED and its sister agency, the Energy, Minerals, and Natural Resources Department, to, quote, jointly develop a statewide enforceable regulatory framework to ensure reductions in oil and gas sector methane emissions and to prevent waste from new and existing sources, unquote. Part 50 responds to both the requirements of the Air Quality Control Act as well as the directives of the governor's order, because regulations that reduce emissions of ozone precursor pollutants have the co-benefit of reducing methane emissions. Ms. Keene will testify regarding the rule development process and the numerous opportunities for stakeholder and public involvement throughout that process. Those opportunities have continued during this formal phase of the rulemaking right up to this day. The department granted every request by the parties to meet with us, and we listened to the input and concerns of the stakeholders. We have made every effort to carefully consider and respond to that input, as evidenced by the substantial revisions we have made to the rule, shown in the red line version filed last week. Now turning to the department's testimony. Several witnesses will provide background information for testimony on the specific rule requirements. Ms. Rosso and Mr. Morris will discuss the chemistry of ozone and how it is formed in the atmosphere. Mr. Ellington and Mr. R will explain the department's air monitoring system and how data on ozone levels are collected, verified, and provided to EPA. They will testify as to how compliance with the NAAQS is established using statistics called design values and how EPA calculates those values based on the monitoring data. Mr. Baca will testify regarding the department's ozone attainment initiative, which was undertaken to address the rising ozone concentrations in the state and to support the board in carrying out its duties under the Air Quality Control Act. Mr. Baca will explain the department's participation in EPA's Ozone Advance program, including the development of the Ozone Path Forward Plan for submission to EPA. The department is proposing that the board adopt the Ozone Path Forward to meet the plan requirement of the statute. That plan includes voluntary measures as well as mandatory measures in the form of regulations. This rulemaking is the first of the mandatory measures outlined in the Ozone Path Forward plan. After this rulemaking, the department will be proposing regulations to address ozone precursor emissions from the transportation sector by establishing vehicle emission standards. As Ms. Ely and I told you a couple months ago, these proposed regulations are under active development, and the department will be back before you later this year with its petition to formally initiate that rulemaking. Now, you will hear from witnesses from industry that the statute constrains the board to regulating only sources in those counties that have an ozone monitor located within their boundaries that is registering design values in excess of 95% of the NAAQS. This is a far too restrictive reading of the statute, and it runs contrary to the statute's obvious intent to keep the state in compliance with federal ambient air quality standards. You will hear from Mr. Baca that the department's ozone monitors are located within air quality control regions established by EPA. These regions do not follow county lines, nor do the oil and gas bearing formations where the target sources are located. And importantly, any non-attainment designation, if that were to come about, would not necessarily follow those lines. The department has used county lines for the purpose of establishing well-known boundaries with which the rule applies, and has proposed inclusion of all counties with a significant number of emission sources that are within the air quality control regions with monitors that have been exceeding 95% of the standard. This approach fully aligns with the language and intent of the statute. To support this rulemaking, the department contracted with Ramel, the top modeling firm in the country, to conduct regional photochemical modeling predicting the effects of the rule on ozone concentrations. Mr. Morris will testify to that extensive effort and the results, which clearly demonstrate that this rule will achieve meaningful reductions in ozone concentrations that could make the difference between an attainment or non-attainment designation or a lower or higher non-attainment classification. The results of the modeling, as well as the voluminous technical support documents and work products generated by Ramel, have been posted on the Western Regional Air Partnerships website since May for review by stakeholders and the public. Additionally, at NMOCA's request, the department arranged for Mr. Morris to provide the modeling files consisting of over 8 terabytes of data to NMOCA's modeling expert so that he could review the underlying assumptions structuring the model. It is important for you to note that the modeling conducted by Ramel assumed that all modeled sources were in compliance with existing permit limits and federal regulations. Cindy Hollenberg of the Bureau's Compliance and Enforcement Section will testify regarding widespread compliance problems across the industry in recent years that have resulted in the known release of millions of pounds of excess emissions. Given the proposed rule's numerous provisions designed to aid industry and the department in ensuring compliance, it is likely that the rule will have an even greater impact on ozone concentrations than what is shown by the modeling. To assist with developing the provisions of the rule itself, the department contracted with Eastern Research Group, a national environmental consulting firm that frequently works with EPA on federal regulatory efforts. To develop the rule requirements, the department and ERG drew upon the work of the Methane Advisory Panel convened under the Governor's Executive Order, as well as existing regulatory provisions and information from other states and EPA. Using data from the Air Quality Bureau's environmental database, ERG compiled equipment inventories, which were used to develop estimates of costs and emissions reductions for the rule. These inventories, cost estimates, and emissions reductions are thoroughly documented in numerous spreadsheets, which also include detailed explanations of the data. NMED posted this documentation on its website in early June so that all stakeholders had access to it in developing their technical testimony. Ms. Keene's testimony details the equipment and processes targeted by each section of the rule and the specific applicability, emission standards, monitoring, and record-keeping requirements for those sources. Mr. Palmer discusses the requirements and supporting technical data from other state and federal regulatory efforts that formed the basis for the emission standards proposed in each section and the estimated costs and emissions reductions from implementation of those requirements. NMOGA and IPA&M have submitted testimony citing the costs associated with the rule as a reason for the board to significantly limit the reach of the rule or to outright reject it. NMOGA even commissioned its own economic analysis from John Dunham, owner of a New York City-based consulting firm, Guerrilla Economics. In contrast to the extensive data, thorough documentation, and detailed explanations provided by the department in support of its cost estimates and modeling, Mr. Dunham's 10-page analysis is severely lacking in supporting data, explanations, and transparency regarding his model. This analysis reads less like comprehensive expert testimony intended to fully inform the board, and more like lobbying material designed to induce fear in the legislature and generate media headlines. And on that score, it succeeded. While clearly an effective lobbying piece, this study does not come close to being sufficient for serious consideration by the board, as the testimony from the departments and other parties' witnesses will show. The fact that NMOGA was willing to submit this material as expert technical testimony for the board to rely on should make you question the validity and reliability of other representations they are making in this proceeding. This rule does contain important provisions to provide regulatory relief for smaller independent operators. Ms. Keene and Ms. Day will testify regarding the small business facility definition in the rule, the data that support that definition, and how it limits the requirements that small operators must comply with. IPA&M dislikes this definition and seeks to have the board return to the approach proposed in the department's first pre-petition draft of the rule, which broadly exempted all low-producing wells from the requirements of the rule. But that approach was ultimately rejected because it simply leaves too many emissions on the table and is not tailored to small independent operators. Low production does not necessarily equal low emissions or low overall company revenues. The department has repeatedly asked IPA&M to engage with our data and suggest ways to improve the small business facility definition. For instance, they could propose different thresholds that would apply to more of the companies they claim should be included, or different ways of calculating those thresholds. But they have simply refused to do so. The rule also provides relief for smaller, lower emitting facilities by establishing emissions thresholds throughout each section of the rule that exempt sources with low emissions from compliance with the requirements. And there are flexibilities provided throughout the rule that allow operators to determine the best way to achieve compliance based on their particular operations. One example is an alternative compliance plan that can be proposed for department approval to allow operators to achieve compliance with required emissions reductions across their entire fleet of equipment rather than on a source-by-source basis. Will there be impacts on industry if the board adopts this rule? Yes. Any new regulation will necessarily entail costs to the regulated community. Will there be public health and environmental impacts and cost to industry in the state if EPA designates these areas as non-attainment for the ozone NAAQS? You can bet on that. Failure of the board to act, while it may delay such costs, will not avoid them. If the board does not take action to address sources of ozone precursors, the federal government will. The department believes, and the testimony will demonstrate, that the proposed rule before you is reasonable and workable for both industry and the department, and appropriately balances the regulatory burdens on industry against the interests of the state in complying with federal air quality standards, and most importantly, the interests of communities in reducing harmful air pollution that is detrimental to public health, welfare, and the environment. The department thanks you for your service and looks forward to putting on its case.
Thank you, Ms. Katz. Ms. Fox, would the Clean Air Advocates like to make their opening statement at this time?
Yes, Madam Hearing Officer, thank you very much. Good morning, Madam Hearing Officer, Madam Chair, and members of the board. I'm Tanis Fox with Western Environmental Law Center, here today with my co-counsel, David Bach. We thank you for your time during this proceeding. This rulemaking is one of the most complex, if not the most complex, that has come before this body, and we appreciate the significant effort and resources this hearing will take. We represent 9 parties in this proceeding: Conservation Voters New Mexico, Dene Care, Earthworks, National Parks Conservation Association, Natural Resources Defense Council, San Juan Citizens Alliance, Sierra Club, 350 New Mexico, and 350 Santa Fe. For shorthand, we refer to our clients as Clean Air Advocates. All these organizations share an interest in making sure the rules adopted by the board are as strong as possible in order to reduce ozone precursors that create harmful ground level ozone, reduce methane, an extremely potent greenhouse gas that contributes significantly to our planet's warming, and protect public health, especially that of frontline communities most impacted by oil and gas operations. The ozone precursor rule put forth by Secretary Kenny and Environment Department staff is a strong rule, and we appreciate their work over the last 2 years that has gotten us here today. Governor Lujan Grisham has led the way through her commitment to pass, quote, the country's toughest methane and air pollution rules. We would like to see the governor's commitment to passing the strongest rules in the nation translated into the final rules adopted by the board. In our direct testimony, Clean Air Advocates joined forces with the Environmental Defense Fund, Center for Civic Policy, and NAVA Education Project to put forth 4 proposals that strengthen NMED's proposed rule in significant ways. And since our filing, we engaged in highly productive discussions with Oxy USA Inc., one of the top oil and gas producers in the state. In our rebuttal testimony, our coalition and Oxy came to agreement on a number of proposals, including on all 4 of our initial proposals, with some modifications from our direct filing. And since our rebuttal filings, we have also had productive discussions with the National Park Service and are very pleased that the Park Service supports our completions, pneumatics, and tank measurement proposals. We believe that our proposals, supported by an expanded and diverse coalition that includes a top producer and the federal government, deserve serious consideration by the board, and that adoption of our proposals, combined with NMED's proposed rules, will put New Mexico on the map with nation-leading rules as promised by the governor. I'd like to summarize our proposals in the testimony we will present in support. First, we propose more frequent leak detection and repair inspections, or LDAR, at oil and gas facilities that are located 1,000 feet within homes, businesses, and schools. Our proximity proposal, as we call it, is modeled after a rule already adopted in Colorado and is set forth in Section 116 of the proposed rule. More frequent LDAR inspections translate into greater emissions reductions. Relying on EPA technical documents, NMED estimates, for example, that conducting EPA Method 21 inspections on a quarterly basis translates to an 83% reduction in emissions from leaks, and that monthly inspections translate into a 92% reduction. These are huge emissions reductions, and we know that leaks from oil and gas operations are a major source of emissions of air pollutants in New Mexico. In support of our proximity proposal, you will hear from Leanne Hill. Ms. Hill has a master's in public health from the University of California at Berkeley and is a senior scientist at Physicians, Scientists, and Engineers for Healthy Energy. Ms. Hill provides extensive testimony on the public health impacts of volatile organic compounds, or VOCs, including VOCs like benzene that are hazardous air pollutants. She will discuss peer-reviewed studies indicating that living in close proximity to oil and gas facilities results in increased health risks and impacts from elevated pollution levels, and that these health risks decrease further away from these operations. These impacts include increased risk for cancer and risk to humans' respiratory, neurological, and cardiovascular systems. Our proximity proposal helps protect frontline communities who bear the brunt of the impacts of oil and gas operations. EDF estimates 35,000 New Mexicans live within 1,000 feet of oil and gas sites, and that over half are people of color and indigenous people. This board has the authority to consider environmental justice impacts of this rule, and our proximity proposal helps mitigate impacts to communities of color who live close to oil and gas operations. For our second proposal, you will hear about these impacts from one of those people who lives next to oil and gas operations, Don Schreiber, a rancher from Rio Arriba County. There are 122 wells in and around Mr. Schreiber's land and 33 within 1 mile of his home. Mr. Schreiber understands the impacts of oil and gas firsthand and will provide testimony in support of our proposal to require reduced emissions completions or green completions during development or redevelopment of a well. Mr. Schreiber will explain to the board how, as early as 2008, he and his wife reached agreement with ConocoPhillips to undertake reduced emissions completions on their land. However, after Hillcore Energy Company acquired ConocoPhillips assets in 2017, it has refused to continue ConocoPhillips' program, Reduced Emissions Completions. Our Reduced Emissions Completions proposal has already been adopted by Colorado and would require capture of emissions during all stages of completion and recompletion of wells, instead of allowing emissions of pollutants to be vented to the atmosphere. EDF technical witness Tom Alexander will explain why this proposal, set forth in newly proposed Section 127, is technically feasible. Our third proposal would accelerate retrofitting of pneumatic controllers with what are called zero bleed controllers, or controllers that do not emit gas and the air pollutants contained within. Clean Air Advocates is fortunate to have the expertise of a national expert, Dr. David Mccabe, who helped develop our proposal and will testify in support of it. Dr. Mccabe is an atmospheric scientist with the Clean Air Task Force, has a Bachelor of Arts in Chemistry from the University of Chicago and a PhD in Physical Chemistry from the University of Colorado. He has also been heavily involved in the methane rulemakings in Colorado. As Dr. Mccabe will explain in his direct testimony, pneumatic controllers are big emitters. Some, powered by gas, are actually designed to emit gas and the pollutants they contain, and many malfunction and emit pollutants. The Clean Air Task Force estimates there are over 118,000 pneumatic controllers in New Mexico that emit an estimated 30,000 metric tons of VOCs and 108,000 metric tons of methane. EDF analysis indicates pneumatic controllers are the second largest source of methane from oil and gas in the state. Any rule designed to reduce ozone precursors must include a robust schedule to retrofit pneumatics. The proposal we put forth before the EIB has been negotiated with Oxy. The retrofit schedule is somewhat less aggressive than that in Colorado, but it is nonetheless much stronger than what NMED proposes, and it is technically and financially feasible for operators, as demonstrated by Oxy's support and Colorado's adoption of a somewhat more aggressive schedule. Dr. Mccabe will also explain why our pneumatics proposal, set forth in Section 122, is cost effective, why NMOGA's cost estimates are inaccurately high, and why NMED's cost estimates are conservatively low. Finally, Dr. Mccabe will explain our fourth proposal to the board. This proposal would require tanks at new or modified oil and gas sites to use what we call a storage vessel measurement system. The system gauges the quantity and quality of liquids into a storage vessel or tank. Typically, liquid levels in a tank are measured by opening a thief hatch on top of the tank and inserting a gauging device, and samples are collected by opening the hatch. But when the hatch is opened, air pollutants, including VOCs and methane, are released. Since gauging is often performed frequently and the hatch is opened every time a measurement is taken, these emissions can be significant. Our proposal is set forth in Section 123 of the rule, is modeled after Colorado rule, and is cost effective for operators. That rounds out Clean Air Advocates' proposals and list of witnesses. Thank you again for your time and attention during this important proceeding. This rulemaking is critically important for New Mexico. We have a number of counties that are bumping up against the ground level ozone standard. This has real implications for public health. And we have a methane hotspot in the Four Corners area, which has real implications for climate warming. But make no mistake, this rulemaking has significance beyond our borders. EPA and other states are watching this proceeding. New Mexico's rule will serve as a model for the federal government and other states in adopting their own rules to prevent formation of ground level ozone, combat climate change, and protect public health. We urge the board to follow through on the governor's commitment to pass nation-leading rules. Thank you again for your time, and we look forward to putting our case before you.
Thank you, Ms. Fox. Ms. Paraños, would you like to make your opening statement now?
Yes, Madam Hearing Officer, thank you very much. Good morning, members of the board, Madam Hearing Officer. Thank you for the opportunity to present an opening statement in this important proceeding. I am Elizabeth Praños, Counsel for the Environmental Defense Fund. EDF is a national membership organization with more than 2.5 million members residing throughout the US and more than 18,000 residing in New Mexico. Many of these members are deeply concerned about the pollution emitted from oil and natural gas sources. EDF brings a strong commitment to sound science, collaborative efforts with industry partners, and market-based solutions to our most pressing environmental and public health challenges. EDF strongly supports the proposed NMED rules. We commend the agency on proposing a strong rule and recognize and appreciate the tremendous amount of time and resources NMED staff has put into its rule and supporting documentation. We appreciate NMED's adoption of our proposal to require gas-powered pneumatic controllers be included in equipment leak inspections, or LDAR, as well as other revisions NMED has made in response to our and our partners' suggestions. That being said, we, in conjunction with other NGO partners and Oxy USA, propose a suite of improvements that will further reduce pollution emitted from oil and gas facilities in a cost-effective and technically feasible way. We believe that by adoption of these improvements, the board can finalize a rule that will meet Governor Lujan Grisham's goal of promulgating a nationally leading set of requirements. These joint improvements include more frequent leak inspections at occupied places such as homes and schools, as Ms. Fox just reviewed, a proposal to hasten and increase retrofits of gas-powered pneumatic controllers, a requirement to control emissions from flowback vessels during well completions and and recompletions, installation of a tank measurement system on new storage tanks, and additional clarifications and revisions to the leak detection and repair and tanks provisions intended to ensure the benefits of the requirements match the cost, the rules allow for technological innovation, and are clear and workable. As evidence presented by EDF will show, deep reductions in ozone precursor emissions are necessary in order to protect the health of New Mexico residents and its environment from unhealthy and dangerous levels of ground level ozone. At the same time, New Mexicans are experiencing increased drought, wildfires, and unhealthy air pollution caused by our warming climate. Methane emissions co-emitted with VOCs from oil and gas facilities are a primary contributor to climate change, in particular to near-term warming. As NMED has pointed out, reducing VOC emissions will also reduce methane emissions, since the two pollutants are inextricably tied and co-emitted as components of natural gas. The governor directed NMED to promulgate rules to reduce methane emissions. While the primary aim of this rulemaking is to reduce VOCs and oxides of nitrogen that contribute to ground level ozone, it is incontrovertible that VOC reductions will also reduce methane as a co-benefit. EDF's first witness will be Maureen Lackner, an economist for EDF. Ms. Lackner's opinion is that the Dunham report has overstated costs, fails to account for the social costs of oil and gas pollution, and is based on a faulty model that lacks transparency and has not undergone a sensitivity analysis. Ms. Lackner will tell you she agrees with NMED's witness, Susan Day, that you should give their report no weight. You will next hear from Dr. Tammy Thompson, a senior air quality scientist with EDF. Dr. Thompson will explain that NMED's ozone modeling demonstrates that VOC emissions from oil and gas sources are contributing to unhealthy levels of ozone in New Mexico, and that adoption of rules to reduce emissions, as NMED and EDF have proposed, are necessary to protect air quality. Next, you will hear from Dr. David Lyon, a senior scientist at EDF. Dr. Lyon will discuss some of the definitions EDF proposes in conjunction with Oxy and our other NGO partners for Section 116, the equipment leak requirements. Dr. Lyon will next describe the results of 16 peer-reviewed studies, including 5 in the Permian Basin in New Mexico, that demonstrate the cost-effectiveness of frequent leak inspections as proposed by NMED and as proposed by the EDF NGO Oxy LDAR proximity proposal that requires increased inspections at public occupied places such as homes and schools. The studies, which are based on direct measurements, demonstrate that the pollution emitted from oil and gas facilities in New Mexico is magnitudes higher than traditional inventories suggest. For example, one study conducted by Robertson et al. Suggests that New Mexico Permian Basin methane emissions are 10 times higher than operator reports to EPA pursuant to EPA's greenhouse gas reporting rule. As Dr. Lyon will explain, one reason for the difference between operator reported emission estimates and measured emissions is the failure of traditional inventory estimations to account for improperly operating conditions or super emitters. Dr. Lyon will explain that such super emitters are mainly intermittent, which indicates the need for frequent, comprehensive inspections to detect leaks from equipment. You will also hear from Dr. Lyon the results of studies, including one in the Permian Basin, that demonstrate the need for recurring leak inspections at low producing wells. You heard a little bit about this topic from Ms. Katz earlier. These studies indicate low production wells are likely a disproportionately large share of U.S. oil and gas emissions. Dr. Lyon will explain why the board should reject NMOGA's proposal to reduce the inspection frequency for wells that have a potential to emit of less than 10 tons per year of VOCs in light of the findings of these scientific studies. Next, you will hear from Hillary Hull. She is Director of Research and Analytics for EDF. Ms. Hull will provide evidence demonstrating the cost effectiveness of NMED's proposed LDAR requirements and of the EDF NGO Oxy LDAR proximity proposal. Ms. Hull will explain that NMED has likely underestimated the costs of frequent leak detection and repair requirements, not overestimated costs, as NMOGA suggests. Further, Per Ms. Hall's analysis, the per well site cost of conducting semi-annual inspections is 30% lower than NEMED's estimate, making NEMED's estimate of cost effectiveness of LDAR quite conservative. Ms. Ho will also note that our joint LDAR proximity proposal will increase reductions associated with NEMED's proposed rule by 3,600 tons of VOCs at an average cost of only $894 per ton of VOC reduced within the proposed 1,000-foot boundary of our LDAR proximity proposal. Ms. Ho will also discuss the important co-benefits associated with increased inspections. Per her analysis, additional inspections at homes, playgrounds, and schools will remove 14,300 tons of methane and 150 tons of hazardous air pollutants, including benzene, from the air annually. Importantly, these reductions will help protect the air breathed by over 35,000 New Mexicans living near oil and gas well sites, including 2,700 children under the age of 5, 19,000 people of color, including over 5,800 Native Americans, and 4,500 adults 65 years or older. You will hear additional testimony from Dr. Thompson regarding the scientific underpinnings of our LDAR proximity proposal. Ms. Thompson will underscore that adoption of our proposal to increase inspections at well sites near occupied places such as homes and schools will result in the removal of additional tons of VOCs, thus helping New Mexico avoid falling into ozone non-attainment. Second, she will discuss results of a Colorado Department of Health study that found that persons living within 2,000 feet of oil and gas production well sites are at risk of developing cancer, as well as non-cancer adverse health impacts due to exposure from toxic VOCs. Tom Alexander, a former vice president with Southwestern Energy, will provide additional support for the joint LDAR proximity proposal to increase inspections at well sites located near homes, based on his 18 years experience working for Southwestern Energy. Southwestern Energy's experience implementing their own LDAR program helped the company reduce leaks, optimize operations, and develop preventative maintenance procedures. Moving on to the topic of liquids unloading, Mr. Alexander will provide testimony in support of NEMED's proposed requirements to use a form of artificial lift or other approved control technology to reduce venting from liquids unloading activities and minimize the need for manual unloading. With respect to controlling emissions from natural gas-powered pneumatic controllers, one of our proposals, both Dr. Lyon and Mr. Alexander will express support for the joint EDF-NGO Oxy proposal that increases the pace and amount of conversions to non-emitting pneumatic controllers. Mr. Alexander will note that the EDF-NGO proposal is economically reasonable and practical as technologies exist today to eliminate emissions from pneumatic controllers. Mr. Lyon's testimony is rooted in the results of scientific, peer-reviewed studies that demonstrate high emissions from malfunctioning gas-powered pneumatic controllers. While frequent inspections can help reduce emissions from malfunctioning pneumatic controllers, the surest way to eliminate emissions is to replace gas-powered devices with non-emitting ones. You will also hear from Mr. Alexander support for our joint proposal to require operators install tank measurement systems on new storage tanks and to allow for the use of alternative approved control technology to control emissions from low-emitting storage tanks. Ms. Hill will testify to the reasonableness of the NEMED cost-effectiveness estimate for its tank control requirements. And lastly, you will hear from Mr. Alexander support for our joint proposal with Oxy to require operators control emissions from flowback vessels during completions and recompletions. Mr. Alexander will explain why the joint proposal is safe, economically feasible, and technically practical. Again, I greatly appreciate the opportunity to testify on this important rulemaking and appreciate the hard work of NME staff, this board, and Madam Hearing Officer. Thank you.
Thank you, Ms. Pranius. Mr. James, would you like to make an opening statement now or reserve?
Thank you, Madam Hearing Officer. I'm going to speak for their Center for Civic Policy and the NAVA Education Project. I'd like to start with a thank you.
Mr. Shemanek, hold on. Please introduce yourself so that the court reporter knows who you are.
Sorry. Yes, my name is Travis Shemanek. I'm a clinical law student from the University of New Mexico School of Law, National Resources, and Environmental Law Clinic, representing the Center for Civic Policy and the NAVA Education Project. Thank you, Madam Hearing Officer and Madam Chair and the Environmental Improvement Board members for your time and effort in this matter. The focus of our clients is to ensure that the regulations provide strong public health protections from ozone precursors, especially those in marginalized and underserved communities, such as Native American populations, those with limited English proficiency, and for people who live near oil and gas wells. Some background on the Center for Civic Policy and the NAVA Education Project. The Center for Civic Policy empowers and amplifies historically excluded and underrepresented New Mexicans for increased voter participation to increase equitable representation in the community. The Center for Civic Policy is here to make sure that their community's interests are equitably represented in this matter for the rulemaking hearing. Similarly situated is the NAVA Education Project, whose mission is to unite community stakeholders to actively improve the quality of life for Native American communities and to protect Native American culture. NAVA Education Project is committed to social, economic, and environmental justice principles that advance a healthy and sustainable community for the Native American families living in New Mexico. We will be presenting 3 witnesses in this hearing. Mr. James Poviwa will be representing the Center for Civic Policy. Mr. Joseph Hernandez will be representing the NAVA Education Project. And Professor Cliffia will be supporting both the Center for Civic Policy and the NAVA Education Project. Mr. Poviwa of the Center for Civic Policy and Mr. Hernandez of the NAVA Education Project will both testify about their respective organizations' missions and relevant work with underserved communities, and why this has led their organizations to join with the Environmental Defense Fund, the Clean Air Advocates, and other parties in supporting amendments to strengthen the proposed regulations. They will speak about the particular importance of provisions to require more frequent leak detection and repair on facilities in close proximity to where they live, work, and their children go to school. Professor Cliffia will be supporting his testimony by offering rebuttal testimony from an environmental justice standpoint in response to the testimony of several parties that have proposed both strengthening and weakening leak detection and repair regulations. He will testify how the facts presented by different witnesses relate to the disparate impacts on local communities and how that in turn relates to the board's requirements to consider potential disparate impacts of any regulations on the marginalized populations. We would just like to reiterate the environmental justice perspective we believe the board needs to consider and the disparate impacts they have the power to mitigate for local communities through the adoption of our strengthened proposals. Thank you. That concludes my opening statement.
Thank you very much, Mr. Shemanek. Mr. Vimont or Vermont on behalf of National Park Service.
It's okay. Okay, my video came up. My name is John Vimont. I'm the acting chief of the National Park Service's Air Resources Division. It's a national office that serves parks throughout the national park system. Several National Park Service units in and near New Mexico measure exceedances of the ozone air quality standard, particularly at Carlsbad Caverns National Park. We will provide information on enhanced measurements of volatile organic compounds, VOCs, and nitrogen oxides taken at Carlsbad Caverns National Park that strongly support the need for this rulemaking. We'll also provide some suggestions that will strengthen the rule. I appreciate the opportunity to testify before the board today and appreciate all of your work in this area. Thank you.
Thank you, Mr. Vimont. Turn then to Wild Earth Guardians, Mr. Nykiel or Mr. Timmons. Would you like to make an opening statement now?
Yes, please, Madam Hearing Officer. Thank you, Madam Hearing Officer, Madam Chair, members of the board. My name is Matt Nykiel, and with me today is Daniel Timmons. Together, we represent Wild Earth Guardians. Thank you for the opportunity to present this opening statement regarding the Environment Department's proposed rules, which are critical to protecting the public health and environment of New Mexico. As you will hear from our witness, Mr. Jeremy Nichols, the department's proposed rule is a good step forward, but could be made better. Mr. Nichols will present evidence supporting 3 targeted proposals to improve the rules by providing greater public transparency, comprehensively addressing precursor emissions, and providing a backstop to prevent the ozone problem from getting worse. Wild Earth Guardians is a nonprofit conservation organization whose mission is to protect and restore the wildlife, wild places, wild rivers, and health of the American West. Guardians was founded and is headquartered in Santa Fe and represents thousands of members and supporters, many of whom live in New Mexico, and deeply hope this board adopts the strongest possible rules that will finally get New Mexico's ozone problem under control. To be clear, getting New Mexico's ozone problem under control isn't just about complying with an abstract numeric standard. It's about protecting public health and giving people the peace of mind that they can safely breathe the air in New Mexico. As you will hear today, for the past several years, New Mexicans across the state have been breathing air that is demonstrably unhealthy. So far, 2021 has been no different, as the state continues to rack up ozone exceedances. Responding to this serious pollution problem and to actions by the Trump administration, which stripped federal air quality protections that New Mexico relied on, the New Mexico State Legislature and Governor Michelle Lujan Grisham authorized and directed this board to adopt New Mexico-based rules to address the unique air pollution challenges of this state. You will hear a good deal of testimony regarding air quality modeling and future projections, but the data on the ground today is very clear. New Mexico has a serious ozone problem, and no longer can this state afford to simply do the bare minimum by meeting the basic federal standards. The Ozone Attainment Initiative, including the proposed rules at issue in this proceeding, must go farther if this board is serious about its mission to protect public health. With over a decade of experience working on air quality rules that address ozone pollution in states including New Mexico, Colorado, and Utah, Guardians witness Mr. Nichols will highlight the important context within which the board will consider these rules, including the fact that the oil and gas industry is a predominant source of ozone precursor emissions, the importance of adopting strong rules the first time to avoid the persistence of ozone pollution other states have experienced even after adopting similar rules, the alarming number of ozone exceedances recorded just this year, and how increasing ozone pollution and the increasing impacts of climate change are forecast to feed on each other. Given the context of the ozone problem in New Mexico, Mr. Nichols will present 3 proposals to strengthen the department's rules. First, Mr. Nichols will testify in support of a rule that requires all owners and operators to submit a semi-annual report to NMAD identifying deviations from the rules in Part 50. Reporting requirements like these are an essential feature of most, if not all, pollution control rules, and these reports would provide all members of the public transparent access to whether or not a particular operator or facility, maybe in their community or their backyard, is following the rules. As the department's rules are currently drafted, only the Environment Department can request this information if they do so at all. Mr. Nichols will explain how limiting access to this information to a chronically underfunded and short-staffed state agency is risky, and how the department's discretion to request these reports could lead to inequities in oversight and enforcement and perpetuate environmental injustice against historically marginalized communities. Second, Mr. Nichols will testify in support of a rule amendment that accounts for sources of ozone precursor emissions that have historically been overlooked. Mr. Nichols will explain how a recent report conducted by the UCLA Institute of the Environment and Sustainability identified the likelihood that a significant number of oil and gas facilities emit ozone precursors during wellhead construction, and that the emissions during this phase of development are not currently accounted for or regulated by the Environment Department. Finally, Mr. Nichols will testify in support of a common sense rule that authorizes the Environment Department to deny new air quality permits for oil and gas facilities that would add more ozone precursors to areas of New Mexico that already exceed 95% of the ozone standard. Mr. Nichols will explain that despite years of ozone exceedances in New Mexico, year after year, the oil and gas industry continues to secure new air quality permits that allow more ozone precursors to be emitted, making the ozone problem harder to solve. This rule would create a critical backstop that accounts for the fact that many of the new rules proposed by the Environment Department do not become effective immediately. As you will hear from the industry parties, it will take owners and operators time to reduce their pollution levels according to the new rules. And while we're waiting for that, the rules should ensure the ozone problem doesn't keep getting worse and therefore more difficult to solve. We thank the board for the opportunity to provide an overview of our case, and we thank you for your time and consideration of strong New Mexico-based rules that will finally start to address the state's ozone problem and provide New Mexicans an essential comfort that the air they breathe is clean and healthy. As you consider these rules, we encourage you to bear in mind your charter set forth in New Mexico's Environmental Improvement Act, Section 74-1-2 NMSA, which directs you as EIB members to, quote, ensure an environment that in the greatest possible measure will confer optimum health, safety, comfort, and economic and social well-being on its inhabitants, will protect this generation, as well as those yet unborn, from environmental threats, from health threats posed by the environment, and will maximize the economic and cultural benefits of a healthy people. Thank you.
Thank you, Mr. Nutkill. Mr. DeSalen.
Thank you, Madam Hearing Officer. Good morning, Madam Chair, Mr. Vice Chair, members of the board, and Madam Hearing Officer. My name is Charles DeSalen. I'm a staff attorney with the New Mexico Environmental Law Center, and I'm representing the New Mexico Environmental Law Center in this proceeding. We appreciate the opportunity to appear before you today in this very important rulemaking proceeding. New Mexico Environmental Law Center is a nonprofit public interest law firm that represents environmental and community organizations on a wide variety of environmental and environmental justice issues here in New Mexico. The New Mexico Environmental Law Center has approximately 750 members. We have been a participant in this rulemaking proceeding from its inception. We also participated in the related rulemaking proceeding before the Oil Conservation Commission, addressing waste from oil and natural gas production. We were represented on the methane advisory panel, which developed the technical groundwork for these regulations. We also submitted lengthy comments on the Oil Conservation Division draft waste rules. And we gave public comment and expert technical testimony during the Oil Conservation Commission hearing on those rules. We submitted detailed comments to the Environment Department on earlier drafts of the proposed ozone precursor rule that we're discussing here today. The proposed regulations would address emissions of oxides of nitrogen, or NOx, and volatile organic compounds, or VOCs, from oil and natural gas production. These pollutants are harmful to human health. For example, one of the VOCs that is emitted from oil and gas production is benzene, a known human carcinogen. NOx and VOCs react with sunlight and oxygen in the atmosphere to form ozone. Ground level ozone is also harmful to human health. The co-benefit of these regulations would be the reduction of methane emissions from oil and natural gas production. Methane is a potent greenhouse gas. it is approximately 86 times more potent than carbon dioxide over a 20-year period. The New Mexico Environmental Law Center generally supports the rules that the Environment Department has proposed in this proceeding, with a few exceptions. We thank the Environment Department and its staff for the tremendous amount of work that has gone into these proposed rules. There are a few issues that I would like to address. The first issue is the exemptions for lower producing wells. Now, as originally drafted, the rules would have exempted so-called stripper wells. Rules also would have exempted facilities that emit less than 15 tons per year of VOCs. The proposed rules that the Environment Department submitted to the board no longer include those exemptions. We support the department's decision on this issue, and we appreciate the department's actions. Our witness, Teresa Pascual of the Acoma Pueblo, will address this issue from the perspective of Native communities in the San Juan Basin. We likewise oppose the industry proposals to exempt wells that produce less than 15 barrels or barrel equivalents per well per day. The second issue is the phase out of pneumatic controllers. We generally support the Environment Department's proposal to phase out pneumatic controllers which are operated by natural gas. These devices are among the largest sources of emissions from oil and gas production. We agree with the department that these devices need to be replaced with zero emission controllers. Those that are operated by compressed air or by electricity. However, we think that the department's proposal to require a replacement only by 2027 is much too long a time period. We agree with and support the proposal of the Environmental Defense Fund and Clean Air Advocates and other organizations to require replacement within 6 months. The third issue is the third issue is the use of storage vessel measuring systems. The current practice is to measure liquids in tanks by opening a hatch, a thief hatch, and take the measurement manually. This results in substantial releases of pollutants into the atmosphere. We support the proposals to require automatic measuring systems be installed in storage vessels. The fourth issue is the installation of reduced emission completion equipment. Again, we support the proposals of several organizations to require the use of equipment for the completion and reworking of wells undergoing hydrologic fracturing, equipment that will reduce the emissions of harmful pollutants into the atmosphere. The next issue is leak detection or repair, or LDAR. Leaking equipment is another major source of emissions of harmful air pollutants from oil and gas production. Leak detection and repair requirements are extremely important to reduce emissions, especially for people who live, go to school, and work near oil and gas production facilities. We support the strong LDAR requirements. We therefore support the proposal of Clean Air Advocates, the Environmental Defense Fund, the Center for Civic Policy, and NAVA Education Project to require an enhanced LDAR for facilities that are within 1,000 feet of specified occupied areas. These occupied areas include schools, businesses, and homes. On several of these points, I want to say that we support the agreement that has been reached among Oxy USA, EDF, Clean Air Advocates, and some of the other organizations. We commend these parties for reaching an agreement on these issues. We urge the Environment Department to also support this agreement, and we urge the board to adopt the terms of this agreement. Finally, it is important to emphasize that the emissions of harmful air pollutants disproportionately affect Native Americans and Hispanic communities in New Mexico. Our witness, Teresa Pascual, will also address this issue. I would like to add that although we are playing a relatively minor role in this proceeding, that should not be taken in as an indication of the importance of this rule in our view. It is of critical importance. We thank the board for its time and effort in this complex but very important rulemaking proceeding. We urge the board to adopt a strong ozone precursor rule. Thank you.
Thank you, Mr. DeSalen. We have been going for an hour, 45 minutes now, and some of us were on the platform at 8. We need a break. Let's take a brief break until 11 a.m. When we return, I will invite Nemoga to make its opening statement and proceed through the rest of the service list. Thank you.